Good morning. Congratulations for being here, and we're so excited to get to hear from you today. I'm Rita McCann, and I'm an attorney in Huntsville, Alabama. Tom?
Hi, everyone. I'm Tom Vance. I'm a professor of education at Kansas State University. I've known your teacher for many years, and it's really a true testament to you that you're here on the last day in spite of very shaky instruction. No, I'm just kidding. He's a great teacher.
Hello, everyone. My name is Darcy Kern. I'm a professor of history at Southern Connecticut State University. I'm also an alumna of the program and looking forward to hearing you today. Congratulations on getting here.
Right.
Thanks so much. It's great to meet you all. My name is Conrad Drews, and I plan on attending University of Nevada, Reno for political science. And outside of We the People, I do our robotics team and our tennis team.
Good morning, judges. My name is Laura Flynn. I plan to study psychology in the fall at University of Nevada, Reno. And in addition to We the People, I'm the captain of my soccer and softball team and an officer for the National Honor Society.
Good morning. My name is Nicholas Pizka. In the fall, I plan to study economics. And in addition to We the People, I'm in National Honor Society and the captain of the cross country and track and field team. And we're here with our teachers and coaches today, Milton Himes, Ryan Spisman, Ashley Nickel, and Sean McClelland.
Good support. We're so glad. All right. We are Unit 3, going to do question 1. And I will read it and then we can get going. Quoting Oliver Wendell Holmes, I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? And we look forward to hearing from you.
Alexander Hamilton argued in Federalist 78 that the complete independence of the courts is essential in a limited constitution and must declare all acts contrary to the manifest tenor of the Constitution void.
The Supreme Court grants cert to less than 2% of cases appealed, which promotes state resolution of most constitutional issues. We agree with George Mason Law Professor Ilya Soman that judicial review has both promoted federal supremacy and state autonomy at different points in history, but overall has favored the increasing power of the federal government through the court's use of the Commerce Clause and the Supremacy Clause.
Judicial review is the Supreme Court's ability to declare an act of Congress unconstitutional, as established in Marbury v. Madison, an order of the executive as an ex parte Merriman, and acts of states void, as shown in Martin v. Hunter-Lessie.
Initially, in McCauley v. Maryland, the Supreme Court used judicial review to find acts of the federal government constitutional, but constrained the federal government's power in Marbury v. Madison.
The Supreme Court's enforcement of federal supremacy remained through the Civil Rights era, including Loving v. Virginia's reversal of a state law prohibiting interracial marriage. But the tide began to turn in the 1990s under Chief Justice Rehnquist. In cases such as United States v. Lopez, the Supreme Court began to use judicial review to constrain the commerce power in favor of state governments.
Judicial review is inherently a counter-majoritarian practice, but this is necessary in instances when the expedient majority opinion rooted in congressional and state laws are unconstitutional. Counter-majoritarianism is the practice of ruling against popular opinion in order to uphold the principles of the Constitution. For example, in Brown v. Board of Education, the Supreme Court contradicted the popular opinion at the time and their previous precedents set in Plessy v. Ferguson, when Chief Justice Warren wrote, "In the field of public education, the doctrine of separate but equal has no place." This decision was critical in upholding the ideals of equality within the Declaration of Independence and in the Constitution.
Similarly, in Texas v. Johnson, the Supreme Court ruled that the controversial action of flag burning was protected expression under the First Amendment. Although it was unpopular, Johnson paved the way for future protections of symbolic speech, such as wearing an armband and burning draft cards.
The counter-majoritarian practice does not come without negative implications. Yale professor Alexander Bickel presents the counter-majoritarian difficulty, which occurs because Supreme Court justices, in accordance with Article 2, Section 2, Clause 2, are appointed by the President and confirmed by the Senate. They are not directly chosen nor representative of the people. Some argue that this practice is in fact anti-democratic and must not be fully autonomous.
Two limitations which would maintain the integrity of the judiciary would be through Justice Brandeis's 7 rules of Ashwander, specifically judicial minimalism and passive virtue. Judicial minimalism is a self-imposed regulation that advocates for saying no more than necessary to justify an outcome and leaving as much as possible undecided. The justices should also follow passive virtues, the concept that the court should encourage political resolution disputes by the other 2 branches before accepting the case for review.
Supreme Court justices should abide by the limitations proposed by Brandeis's Ashwander doctrine, but the Supreme Court is ultimately in the best position to dictate constitutionality because it is independent from the pressure of re-election that faces Congress, the executive, and state officials. This strong power should only be wielded when absolutely necessary in order to preserve balance among the branches. Thank you.
All right. Thank y'all. In talking about what you said about the independence of the court, we don't have changes of seats on the court very often. Senator Ted Cruz's book, One Vote Away, claims that a single Supreme Court seat can change history. Do you agree? Do you disagree? Explain your response.
I do agree, and this brings up the issue of court packing, which is when a president will expand, or a president or the House will expand the size of the Supreme Court so they can create and enlarge it into a political branch and put people who they agree with politically into the branch to change history.
We can also see that there are cases that are very controversial that have a very close decision of 5-4. We can see this in cases such as Citizens United v. FEC, which changed our political funding and set a huge precedent that corporations do hold the same rights as private citizens. However, it was established in Hahn v. United States that no matter what the vote is, it is a binding precedent to the lower courts that they must follow, showing that even one justice swaying one way or the other can have a huge impact on our politics for a very long time.
I would like to respectfully disagree. We can see there are 8 other justices on the court, and that one justice, while they may have a lot, their voice may have a lot of power, there are 8 other justices that can counteract this.
I disagree. The very important precedent set in McDonald v. Chicago was only a 5-4 decision.
You all want to follow up?
I have a question for you guys. You mentioned the change in the 90s under Rehnquist with the use of the Commerce Clause and states and federalism in judicial review. How has the Commerce Clause been employed by the Roberts Court? Is it similar to the Rehnquist Court, or has it been changed again?
Could you repeat the question?
Sure. So in your speech, you mentioned how the Rehnquist Court in the 90s changed the application of the Commerce Clause in favor of states. How has the Roberts Court, the current Supreme Court, used the Commerce Clause? Has it used it in a similar way to the Rehnquist Court, or has it gone through another change?
I would say that it has used it in a similar way. We can see this in a recent case of Espinoza v. Montana, where the Supreme Court ruled that state programs prohibiting financial aid to students attending religious schools was unconstitutional, that they also ruled that schools have to have an equal basis for providing aid to to students no matter where they choose to go, showing that states they have to follow, the Supreme Court does use the Commerce Clause to regulate how states use their money, and it has to be equally distributed no matter what the circumstances are.
We can also see it in the 26 states that challenged, in the courts that challenged the President Obama's healthcare plan, and how it ruled that that was constitutionally appropriate under.
Okay, I have a question. Excellent job so far. I have a question about the division of power between the national government and the states. It seems fairly clear to me that for most of the court's history, at least the last 125 years, they've tipped the balance towards the power of the national government. Has the Supreme Court tipped the balance, dividing power between the national governments of the states too far towards the national government, or do you think it's about right? What are your thoughts?
It's tipped too far in the state's favor, especially when it comes to things are very fundamental, like voting rights. We can see this in the Voting Rights Act of 1960, or the 1960s, which was recently, or which the pre-clearance clause was recently overturned because it violated the 14th Amendment. I believe it should be reinstated and be applied to every state universally.
I would disagree. I would say the court has recently struck a very good balance between state rights and federal regulation in cases regarding the regulation of COVID restrictions on religious services. We can see this in cases such as Roman Catholic Diocese v. Cuomo and Harvest Church v. Newsom. The Supreme Court ruled that state regulations on capacity limits must be content neutral, despite if they're religious or if they are just a supermarket, showing that they do have some oversight over the states, but every state can determine what their capacity limits are. So that shows that there is an appropriate balance in that regard.
I would like to disagree. I think that the Supreme Court has tipped in the favor of the federal government. We can see in a Bergefeld v. Hodges that the Supreme Court had to protect gay marriage at the federal level because states such as Florida and Indiana still haven't been able to remove their prohibition on gay marriage.
Well, it seems clear from your response that we have a divided court here, which is great. So what kinds of general principles or guidelines can you identify that the court should use in deciding whether to lean towards state power or lean towards federal power? When should the court rule in favor of national power? When should the court rule in favor of state power? If you could think of a general guiding principle, what would that be?
I'm in favor of siding nationally. We've seen our former House of Representative member Diane Watson said that the judiciary has often been the sole proprietor of minority rights, and it will continue to do that. We've seen constant discrimination with things like.
So there's one, Conrad, minority rights, protection of minority rights. When else should the Supreme Court side with the national government?
The Supreme Court should definitely step in through the process of incorporation when following the two-part test, if a right that is fundamental is at risk, and if the only way to protect that right is through incorporation to the states. And we can see this in cases such as Gitlow v. New York, where the fundamental right of freedom of speech was at stake because the states were not protecting it adequately. And this is a case where the federal government had to step in and regulate it.
Good.
I don't believe that the states or that the Supreme Court should make a decision when they should step in on favor of the national or the state governments. They need to remain neutral, and they should be ruling on constitutionality, and they shouldn't have this predetermined thinking, oh, I'm going to rule in favor of the states or in favor of the federal government. They need to remain neutral to effectively do their job.
I disagree. I think that judicial activism is often a good thing. We've seen it be very effective in things like Brown v. Board of Education. And I think that it's necessary today that the judicial branch considers the social outcome and ramifications of a decision.
Thank you.
Well, what do you do if rights come into competition with each other at the state level? Say someone's right to freedom of religion comes into competition with someone's right to marriage. How do you resolve that?
Well, your rights only go as far as the next person's do. So the Supreme Court can't really rule in favor of that. And like my rights to religion are not superior to someone's right of marriage.
So this is all about the Supreme Court and federal district courts striking the right balance between rights, which is extremely hard to do. But in that instance, they might favor religion over marriage because religion has been a fundamental right established under the First Amendment, which receives strict scrutiny under due process of the law. However, in my opinion, there has to be an equal balance because we can't be determining that someone's beliefs are more valid or important than someone else's.
We have recently seen this been balanced in the Masterpiece Cake Shop case, and I think more recently on the state level, there's the religion or RFRA, the Religion Freedom of Restoration Act, which I agree with Harvard Professor Lee Hamilton when she wrote that that RFRA was was essentially as powerful as a constitutional amendment, but was ratified with only a simple majority.
Good timing. Thank you. That was wonderful. Judges, would you all like to give some feedback for us?
I would love to. What a great conversation about one of our most important and complex principles. Let me say a couple things. First of all, your prepared statement was spot on and was very clear, well organized. He answered all of the questions, but the rubber, especially on day 3 of the national finals, really meets the road during follow-up questions. And once again, you were able to marshal ideas and evidence and apply them to some fairly difficult questions. So good work on that. Just a couple of points. Yeah, I think that there can be, this is just my opinion, and I totally respect all of yours, and all of you disagreed, but I think that there are probably some general principles that the court can use in terms of deciding the division of power between the national governments and the states, and you hit on several of them. I just got the time card, so I have other things to say, but apparently I won't be able to say them. So good job, and good job, Mr. Hyams.
I loved it. I'm going to let Judge Kern go because I can tell she's thinking and needs to get her 2 cents in before our facilitator drags us out of the room.
I'll be very quick. You guys did a great job. It was thoughtful. You were very measured in your responses. You were able to answer my question on the Roberts courts. You mentioned both education and healthcare, which is what I was looking for. You did a very good job.
Thank you so much for everyone's time.
Yeah,
Thank you all. It's outstanding. Thank you.
All right, congratulations, everybody.